Hello and welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 17th October to 22nd October 2022. In first important news, the Supreme Court has reiterated that res judicata is attracted at subsequent stage of the same proceedings also. In the case of S. Ramachandra Rao versus S. Nagabhushana Rao, the Supreme Court has held that under Section 11 of CPC, doctrine of res judicata is attracted not only in separate subsequent proceedings but also at the subsequent stage of the same proceedings. The court has further also held that a binding decision cannot lightly be ignored, and even an erroneous decision remains binding on the parties to the same litigation and concerning the same issue if rendered by a court of competent jurisdiction. Such a binding decision cannot be ignored even on the principle of per incuriam, because that principle applies to precedents and not to the doctrine of res judicata. Coming to the second important news, the Supreme Court has held that Part 9b of Constitution is not applicable to local cooperative societies. In the case of Bengal Secretariat Cooperative Land Mortgage Bank and Housing Society Limited versus Alok Kumar, the court has held that the 97th Constitutional Amendment Act of 2011 will not be applicable to local cooperative societies, whereas the same would be applicable to the multi-state cooperative societies and the societies within the union territories. It is important to note that in 2021, the Supreme Court in the case of Union of India versus Rajendra N. Shah had struck down Part 9b on the ground that the amendment was passed without the requisite ratification by the states. Coming to the third important news, the Supreme Court has given some test as to what would amount to substantial question of law. In the case of BSES Rajdhani Power Limited versus Delhi Electricity Regulatory Commission, the court has said that the appropriate test for determining whether the question of law raised in a case is substantial would be to see whether it directly and substantially affects the rights of the parties. The word substantial as qualifying question of law means of having substance, essential, real, of sound worth, important or considerable. It is to be understood as something in contradistinction with technical, of no substance or consequence, or academic. Lastly, the Supreme Court has held that promissory estoppel would not apply against the exercise of legislative power of the state. In the case of Hero Motocorp Limited versus Union of India, the court has observed that the doctrine of promissory estoppel would not apply against the exercise of legislative powers of the state. The court has said there can be no promissory estoppel against the legislature in the exercise of its legislative functions. The only exception with regard to applicability of the doctrine of estoppel is where it is necessary to prevent fraud or manifest injustice. This brings us to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.